Everything here involves public employees in a public school involving a sports program involving minor girls. Okay, so it's an issue of great public importance. A judge will ultimately determine that, whether what the Babinecks are doing is trying to basically chill protected First Amendment expression. But it's very interesting that they didn't file protective orders against Local 12 or WXIX doing reporting on this. They only do that against me. So this is an update on case 2025 CVC 1635, which is Jason and Nicole and KB Babinec suing me and like 6 other defendants for various claims relating to the Milford allegations of inappropriate sexual content or contact in the wrestling program and adults. So the big update here, and I'm going to be looking at some papers here as I go through it and putting them up on screen, is that their lawyer, Theodore Cummings, filed a protective order where he is trying to get restrictions put on me in particular in the process. So, and it's almost, I find it just fascinating. I'm going to try to limit my commentary on it, but I'm not a lawyer. I'm not a super professional lawyer like Mr. Cummings, but I'm going to put up different things as I go. So what happened was on November 29th, I issued some discovery requests that were very narrowly tailored, and you're gonna hear them in a second here. But so he says that I issued these discovery requests, no legitimate attempt to narrow the scope. Well, we'll see. We're going to see what my discovery requests were here in a second, and that they are procedurally premature. They're procedurally premature, so that apparently I wasn't supposed to be allowed to do discovery requests. Well, again, I'm not a super attorney like Mr. Cummings, but I'm going to put up a couple of things. Well, my discovery request had some interrogatories, which are questions that people are being asked to answer. So Mr. Cummings might want to check Civil Rule 33A2 that says, and I'll put it on the screen, interrogatories without leave of the court may be served upon the plaintiff after commencement of the action and upon any party after service of the summons and complaint upon the party. So what did I do, Mr. Cummings? I filed a discovery request with some interrogatories completely consistent with Rule 33A2. Part of my discovery request was for some documents, specifically documents referred to but not provided in the lawsuit. And I'm going to pull up Rule 34B, okay? And it starts, without leave of the court, the request may be served upon the plaintiff after commencement of the action. So I'm not a hotshot lawyer like Mr. Cummings, but I filed a discovery request after commencement of the action, and he claims in his filing that I wasn't allowed to do that. So now, he then says, and I'll put up on the screen, that my written discovery compounds the abuse, because I'm abusing everybody by reporting on stuff. His demands are overbroad, invasive, and seek personal, family, and medical details about minor plaintiff KB and no hearing on the defense. Da, 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 da. Okay, so there's a lot of stuff like this in here. And what I'm going to do is, normally discovery requests are not filed into the case. They are not filed into the case. I never filed them into the case. I never said anything about them, my discovery requests. But now Theodore Cummings has filed those discovery requests into the case. So what I'm going to do, since he did that, is I'm going to actually go through what were my discovery requests. Remember, he says they're harassing, they're this, they're that. Now, by the way, the more I think about this case, I don't even understand why KB is part of the case, okay? So one of the things, in here, if I go through this, I constantly get accused of somehow I harass KB, and we'll come back to it by filming her at the courthouse, and we'll come back to that in a second as I go. But let's start with the discovery request. So this is them. He filed them into the case, not me. Not me. He's the one who did it. So let's get what are some of these requests, okay, that he says are, I guess, evil, overly broad, and so forth. So interrogatories, so these are questions, and it's for all of them. Jason, Nicole, and KB, okay? Identify and quote with particularity each specific statement you believe to be defamatory contained in any video or audio, including web link, date, and time marker made by Christopher Hicks that form the basis of the complaint. Okay? So I'm being accused of defamatory content. The actual suit doesn't specify any specific thing that's defamatory. So I think it's a pretty reasonable question to ask, what specifically are you talking about? Okay? And then the same thing gets asked, interrogatory number 2, identify and quote with particularity each specific statement that you believe to be defamatory contained in any document. So it's otherwise very similarly worded. And then there's a question specifically about KB, okay, about any statement you believe have illegally or improperly identified KB contained in any audio, video, including web link, date, time. So these are things like, so I'm being accused of certain things. So show me what exactly are you saying that did this? Where exactly are you saying in an audio and a video and a report is this coming from? So they go on. These are the kind of questions that I ask, okay, throughout these discovery requests. So, frankly, I don't even understand, again, why KB is part of this case, so then I asked for documents. So I'll put up on the screen. Produce copies of all medical diagnosis and documents and communications with relevant medical doctors as they pertain to being diagnosed with mental distress. This is related to Jason and Nicole. Now, they're the ones alleging they're having all this mental distress. Apparently, they don't understand the concept that if you file a suit and you allege mental distress, I'm allowed to ask you for what's the evidence of this mental distress that you say you have. Did you seek medical treatment? What medical treatment? What diagnosis did you have? Did you have to take some medication? This is all very normal stuff that I'm asking because they're the ones making the allegation. So if they're making the allegation that they've had the mental distress, I'm obviously allowed to ask, what's the evidence that you've had this mental distress? Produce all copies of any written communication you had with counselors that pertain to marriage issues. So in the actual police reports, there's talk of somebody having marriage issues. There's only 2 suspects, Tony Brothers and Jason Babinec, per se, that were involved in this. The names are redacted, so it has to be one or the other. So previously, Tony Brothers told me it wasn't him, so I think it's reasonable to ask what this was because it's referred to in the investigations. So there's some document requests specifically for KB that I make. So in the complaint, there's repeated references to certain specific documents and things. So I asked for those. So produce copies of all text messages received from teammates on January 31, 2024, as referenced in complaint paragraph 20. Okay? So I'm asking for stuff they put in their complaint. How is that overly broad? How is that not related to, how am I asking something that's not related to the case? How am I asking something that I can't ask? You're going to make allegations. By the way, I still don't understand why KB is even part of this case, okay? But produce copies of any evidence of a report, written, text message, email provided to Aaron Zupka on or about May 31, 2024 as referenced in the complaint paragraph 22. So what's so funny is I am a person when I do discovery requests, I'm not a lawyer, but I make them very focused and very net. A lot of lawyers put a lot of bullshit in their discovery requests. I just put very narrow, very tailored. I ask her about, there's a claim of a text message from Peter Fenton that's referred to in paragraph 27, okay? A copy of that text message. These are all very reasonable requests. So then there are a set of admissions for Jason Babinec, okay? So, and these relate to things that are specifically in the investigatory report. So they're in the investigatory report. Theoretically, there could be confusion as to whether it was Tony Brothers or him on some of these things that are in the report. But I try to be careful, and Tony Brothers has denied a lot of this stuff when he talked to me. So that would mean that at least the allegations that are in the report were related to Jason Babinec. So I'm actually not going to put these up on the screen because these are but you can get them from the court. It's a public record. Anybody can go request the docket for this case, and they would see these now because Theodore Cummings filed them into the case. The questions that I was asking, which normally you don't file discovery request into the case, okay? So And that's the only other parts that I'll highlight is that are in the request is request for admissions to KB. Admit that you willingly participated in a Fox 19 WXX interview. It's just so bizarre. I don't know what kind of legal advice these people are getting. So they don't want. I don't really understand how KB has anything to do with the case, to be honest. She had a hard practice. It was like a war. Blah, blah, blah.
According to the lawsuit, a, quote, extreme conditioning session that left multiple athletes vomiting, crying, and passing out was held.
It was honestly a war zone is how I described it.
But what does that have to do with this case? And how was she exactly? I didn't even know who she was until the day before she was on WXIX by name with her parents. I kind of dug around because they kept making reference. I didn't even know who their daughter was. I think I vaguely knew they had a daughter. But then I found out her name, and then I've tried to find any place where I'd ever referred to her, and I couldn't find any place. And then she was the next day, after I found out her name, she was on WXIX with using her name. And talking about stuff that has absolutely nothing to do with the case. So those are some of the discovery requests that are completely on point. Completely clear, and I just don't understand Theodore Cummings. The protective motion for protective order that he submitted is written like it's all emotional. It doesn't have any, it's just all emotional stuff. So let's get to what his requested relief is, or their requested relief is. Okay, redaction of personal information. The full names, addresses, identifying photos, work by Jason, Nicole, KB shall be redacted. Why? Okay, so these records are public records. They are the one who filed the suit. Okay, they are the one who filed the suit. You can't file a suit and then want to be anonymous. You're the one who initiated the legal action, and I just don't understand. The most funnest, interesting one is number 4, which I'll put on screen. Notice of third-party request. Any future subpoenas or public record requests concerning the plaintiffs must be promptly disclosed to the court and opposing counsel with an opportunity to object or seek redaction. So now I'm not allowed to make public record requests to government entities without the approval of the person who is suing me? It's crazy. It is. I think this is going to be a great slap case. A great slap case. We'll see what happens. But I think that these people are trying to use the media. They are using the media with WXX, but they're trying to use the court system to chill First Amendment protected expression and reporting. And in Ohio, we just enacted SLAPP, which is laws specifically against that. Frankly, instead of doing some WXIX bullshit interview, Jason Babinec, there's a reference in here that I referred to him as a coward. I did refer to him as a coward. He's a coward because he won't do a real interview and just deny certain specific allegations on record, on camera, on record. Get it over with. Just get it over with and issue the denials. I mean, I just don't understand. Instead of just doing a real interview and denying the allegations and that have been made by who, not me. The allegations were made by effectively a parent and a coach. And remember, everything here involves public employees in a public school involving a sports program involving minor girls. Okay, so it's an issue of great public importance. It's not some private, it's not something about Jason and Nicole's candle company or anything. It's about something that is of great public importance. Now, they include an exhibit, and in the exhibit, they talk about all the horrible stuff that I've done. Now, they filed this, okay? So it's a public record, and they're the ones who disclosed my discovery request and questions. So this is just complete nonsense. Okay, so it starts with October 8th, 2025. Unauthorized courthouse filming and public posting. First off, you're allowed to film in the courthouse. Okay, there's nothing. You don't need authorization. Okay, and the thing about it is, this is where supposedly, I think this is the thing I did to KB, which I'm going to play it here again. They walked past the camera. Okay, I was going there to attend the protection order hearing involving them filing for a protection order against Courtney Walls. Okay, when I got there, the Courtney Walls was coming down the stairs. I was walking in the door, okay? And because it was already done. The judge or the magistrate went early. So then I'm standing down there, I whip out my camera, I set it up, thinking, okay, I don't even know at this point what the Babinecs look like. And they come down and they walk past the camera. So let's play it. Jason? Are you Jason? Okay, so that is this, so that is what they describe as this. Mr. Hicks secretly recorded video inside the Claremont County courthouse without the knowledge or consent of plaintiffs or court personnel. This recording included clear images of KB, a minor. Hicks then published the footage online where it is widely disseminated. The footage portrayed KB in connection with false sexual misconduct allegations against her father. Allegations never sustained by any investigation. The posting caused KB severe emotional distress, humiliation, and social backlash. Okay, so that's all. Let's play it again. This is KB walking past the camera with her mom and dad, who I don't even know who she is. Jason? Are you Jason? So this goes on and on. So the second thing, civil protection order and retaliation. So I don't know about retaliation. Hicks posted full audio recordings of the hearing. Okay, those are public records. Anybody can go request them. Okay, do they not understand that we live in a free speech culture where government records are largely public records and court matters? When you are initiating court things, maybe Theodore Cummings needs to coach these people a little bit if he can, on that when you're initiating legal actions, it's a little hard to then say nobody's allowed to know about the legal actions or have the audio of them. The court records the hearings. I request the hearing recordings, put them online. Okay, that's called a public record. I just don't understand what they're, this is some sort of retaliation by doing this. And then public mockery and amplification of CPO hearing. Mr. Hicks published a lengthy commentary video in which he played the entire audio of Jason Babinec's CPO hearing involving KB. He added mocking, calling Jason a coward. I did. I called him a coward because he won't just have a straight up real interview and address the questions on the record. He's going through all these theatrics and won't just address these issues on the record. And characterize the agreed resolution as a gag order to science critics. I think it was a gag order. I think in America I'm allowed to have an opinion. This is what the Babinecs don't seem to get, or their lawyer doesn't seem to get, is that in America, last time I checked, okay, in Trump's America, if they file court actions and then I report on them and then I express an opinion about the court actions, you know what that's called? First Amendment protected speech, okay? That's First Amendment protected speech. They apparently don't, they're apparently against that. And they go on and on in this exhibit of all the horrible things. I'll go down to number 5. It says, post-lawsuit campaign of retaliation and misrepresentation. Okay, here's my part of this. November 23rd, Hicks posted the Fox 19 interview segment with Jason, Nicole, and KB, sarcastically captioning it, they out their own daughter. Isn't that exactly what they did? It makes no sense. Their daughter, they want her privacy and this, but then they trot her out on WXIX News to talk about how there was a tough practice that was like a war. This just literally makes no sense. And it says, implying parental hypocrisy and attempting to undermine the family's credibility. I think telling everybody that you're trying to keep your daughter private and secret and then trotting her out on WXIX does undermine your credibility. It absolutely does. Again, that's an opinion. This is America. It's called First Amendment protected speech. But in what mind do these guys think, Jason and Nicole Babinec think, that part of their campaign on their daughter's anonymity, it would make sense to have her be on a local news broadcast by her own name, talking about stuff that has absolutely nothing to do with the lawsuit or the allegations that were involving Jason Babinec. So, and then finally, I'll put up the conclusion here. It says, Hicks' pattern of conduct, harassing pros, dissemination of sensitive court audio, targeted public commentary, and aggressive discovery abuse. Okay, cause ongoing psychological distress and reputational damage. But remember, if I ask, okay, what's the evidence of the psychological distress? Are you going to a psychiatrist? What are you doing? Then it's told, oh no, you're not allowed to ask that. This guy, this is just fascinating. I think that this is a great case that's going to end up being a very important SLAPP case. Remember, SLAPP is relatively new, and it's what is called strategic lawsuits against public participation. It's where people try to use the legal system to chill speech, or to chill things like a coach coming forward with concerns, or to chill things like a parent reporting concerns. Think about what's going on here. Think about if you were a female, like male or female, but let's use female, a female athlete at Milford, and somebody were doing something inappropriate. You told your mom and your dad. How chilled might you be at Milford schools to even come forward? And the Babinecks, you never hear out of their mouth something like, I was a coach in a public school system. I was a public employee. I realized the great trust that's provided in me. And I'm not, why doesn't he say, I'm completely innocent of anything. I did nothing wrong. Any allegation against me wrong. But I respect that when you are in a public role as a public employee involving minor girls, that you're going to be held to a very high standard. And I'd rather err on the side of people feeling comfortable bringing things forward so they get adjudicated than any kid or parent being afraid to bring stuff forward. But this whole thing, that's kind of the update on this protective order thing that they filed. One last thing I want to say, and I'm going to pop up here on the screen, Civil Rule 26C. By the way, Mr. Cummings, you forgot to serve the protective order, Mr. Cummings. You forgot to have a certificate of service in your filing of the protective order. Now, I'm not a lawyer, so I don't want to give you legal advice, but I think that when you have something like that, you should serve it, and it should have a certificate of service, right? That should be part of what you do, but you left both those things out. But here's part of Rule 26C I'll put up on the screen, which has to do, one part of it is about protective orders, and I'll read this. Before any person moves for a protective order under this rule, that person shall make a reasonable effort to resolve the matter through discussion with the attorney or unrepresented party seeking discovery. A motion for a protective order shall be accompanied by a statement reciting the effort made to resolve the matter in accordance with this paragraph. Well, I'm not aware, Mr. Cummings. I can go look through your protective order again. Where's that paragraph, okay? And where was there any attempt on your part to have a discussion, that's specifically in the rule, with me? So like I said, I think this is going to be a great SLAPP case in Ohio. It's an early SLAPP case. It involves journalism, but alternative media type journalism, which is what I am. And I just look forward to it. And I would, I don't know, if I were the Babinecks, I'm not a lawyer, but I would ask my lawyer, do you know what you're doing? Because these filings, I'm sure I'm going to get hit with something here, but I'm going to continue to report. And it just doesn't make a lot of sense, some of these filings. And another thing would be, what if one of the local news channels actually did reporting on this? What if they, put out audio that was of court proceedings that's available to anybody from the court? What if they did that? Would the same thing be happening? Because I don't think it would. Would they be filing a protective? Why hasn't Theodore Cummings filed a protective order against WXIX for broadcasting a segment that revealed information that I talked about? Why didn't he do that? Why didn't he go do that against WXIX? And therein lies even more that this is a strategic lawsuit against public participation. We'll see how it rolls out in the courts. I'm making statements. A judge will ultimately determine that, whether what the Babinecks are doing is trying to basically chill protected First Amendment expression. But it's very interesting that they didn't file protective orders against Local 12 or WXIX doing reporting on this. They only do that against me because they seem to want to have both a shield and a spear. They want to use the court to shield them from somebody like me doing any reporting, but they want to use media like Local 12 and WXIX for reporting, and Signal 99, who, as I've said before, was opining at great depth about this lawsuit before the people named in the lawsuit even knew there was a lawsuit. So somebody had to shop it to them. And I think it'll all come out in the wash. But again, I think this is a great slap case. I'm actually, feel good about it because I've been part of several precedents in Ohio law on different civil rights things, and I think this is a good opportunity on SLAP to do the same here. So that's the scoop, and that's the update on the Babinec lawsuit.